Welcome back to Law and Crime, everybody. It's Jesse Weber again. I know you thought you had enough of me. I came back, but that's okay because we have such an exciting day for you here. We've been recapping a number of different trials, and let's get started once again. Now, today we're going to be covering in the next block our continuation of officer-involved shootings, and how could we not talk about two of the biggest cases that we've covered here on Law and Crime. It's all surrounding the Laquan McDonald shooting. We're going to be covering Jason Van Dyke's trial, as well as the trial of the three officers who were accused of covering up the details of that shooting. And really the most appropriate place to start is the prosecution's opening statement in the Jason Van Dyke case. Remember, this officer was brought on trial for shooting this man. The question becomes, was this a justifiable use of force by that officer, or was this murder? Let's start with the prosecution's opening statement.
That video again is that McElligott is a little bit farther away from Laquan at this point. Laquan is cutting through the parking lot, and he is now reaching Pulaski. At this point, there are police vehicles in front of Laquan as he is walking down Pulaski. There are police vehicles alongside Laquan as he's walking down Pulaski. And there are police vehicles behind Laquan as he's walking down Pulaski. Along this entire stretch of Pulaski Road, Pulaski Avenue, is a 6 to 7 foot chain link fence blocking a vacant lot that's under construction. The defendant continues to pull the trigger of his gun over and over until he empties the entire clip of the gun. In total, this defendant decides to shoot Laquan McDonald not once, not twice, but 3, 4, 5, 6, 7, 8. He's only halfway done. 9, 10, 11, 12, 13, 14, 15, 16 times in total. 16 gunshots into the defenseless body of Laquan McDonald. All of that occurs right on Pulaski, and it's captured on video. You're going to see it right now.
Okay, that was the prosecution's opening statement. Let's break down this case right now with criminal defense attorney and civil litigator Sanford Rubenstein. Mr. Rubenstein, great to have you back here on our new set, Law and Crime.
Love the set.
Well, I'm glad, because it loves you too. Now, let's talk a little bit about this case. Now, the idea of whether or not this was a justified shooting, we kind of heard a little bit about it. First question I have for you, isn't an officer trained to unload their weapon if they think there's a threat? I know the big issue there was the 16 shots fired, but isn't it normal procedure to unload your weapon?
That's a great question, but let me tell you something. This trial revolves around the video, pictures of the truth. There's a video that shows what happened. That is something that's going to be very, very significant to this jury.
And that's a great point. We're going to talk about that video because it's probably the most important piece of evidence in this entire case. But the question is, Laquan McDonald was technically breaking the law that night. And is that something that's going to be hard for the state to argue against?
Look, the penalty for having a knife in your hand is not death.
I agree with you. I agree with you, but the idea that he was walking near police with a weapon in his hands, that's something the defense is going to want to exploit.
Once again, how near was he really? The photos, the video, shows that he wasn't that close.
And the prosecution really wants to stress on the video. Does the defense say, hey, listen, you can't judge everything based upon what that video shows? You have to think about what was in the perspective of Jason Van Dyke.
I would suggest that's a defense when you got nothing else.
That might be the way to do it. But is there a fault to following just technology and not the perspective of an officer?
Look, when the jury's going to see that video and see the distance between the two, the officer and Laquan, they're going to see what really happened here. I've seen the video. You've seen the video. They're not that close.
That video, without that video, we might not have had a case.
I think without that video, the prosecution would have had a real difficult time making a case to a jury. With that video, it's clear that the jury is going to take that into serious consideration when rendering their verdict.
Okay, well, let's see. We saw the prosecution's opening statement. Now let's move on to the defense's opening statement.
Race had nothing to do with this. Race had absolutely nothing to do with this. And there will be no evidence whatsoever to suggest that race is a factor.
Okay, Sanford, you heard the defense attorney say that race is not a factor. But is it? Do you think that aspect really was a factor in this shooting?
Well, I think you have to ask the question, if Laquan McDonald wasn't black and was white, would he still have been shot that many times? Would he have been shot at all?
Well, what do you think? I mean, the idea here is, and you correct me about Chicago crime statistics or the way Chicago police officers conduct themselves. We had a guest on earlier that was talking a little about it. There seems to be a strong problem in Chicago with law enforcement here, and I'm curious your perspective on that.
Well, it's very interesting because I think if any police department needs a pattern and practice investigation with regard to the way it handles its policing, it's Chicago. Yet Sessions, when he was the Attorney General, stopped doing those kind of investigations, which were able to work with municipalities in fixing problems when there was racial injustice in communities. They're not doing those anymore. So it's a real problem today because the one tool that existed, pattern and practice investigations by the Justice Department of police departments in which there is a pattern and practice, are no longer being conducted.
But is it also trials like this, having trials like this, whatever the verdict ultimately becomes, just having this person, having an officer or former officer on trial, does that help at all?
Well, I would suggest, and I'm not saying that's a reason to convict,
right,
but when an officer is convicted, it sends a message to officers all over the country that if you are guilty of murdering someone, you will be held accountable, as well as any ordinary citizen.
The second argument to that, or the counter argument to that, is you don't want officers hesitating or second-guessing themselves in really, really violent and chaotic situations because they're worried about the repercussions. You know, you want them to take decisive action.
Well, I think if you see the video, that wasn't the case here.
Right.
So once again, we turn on this video. Pictures of the truth. So important in this case.
Well, yeah, I'm glad you mentioned that. We're going to talk more about the video. Right now, though, let's get into whether or not this was a justifiable use of force. And we saw the testimony of Yuri Patrick, who's actually a use of force expert. Let's see what his opinion was.
As a use of force expert, was that an appropriate action by those officers calling for the taser?
I think so, yes. I think the officers in general on present were acting appropriately, restricting his movement, hemming him in, trying to isolate him to an area that was not populated. Police officers have to get out of their vehicles. My issue with Officer Van Dyke is his decision to shoot. It was not, at that moment in time, in those circumstances, the standard imminent risk of serious injury or death was not present, and the use of deadly force was not necessary at that point in time.
Okay, so that's a use of force expert who's saying the shooting wasn't justified. Sanford, I'm curious, in your practice, do these experts help the jury, or do the jury say, hey, listen, let's make our own decision. We don't need an expert telling us?
I would suggest a good expert is as important as preparing your witness before trial, because the truth of the matter is experts are very important in honing in on the issues, and their opinion is respected by juries once they've heard their background. And I'm sure this expert had a background that was appropriate for him being a use of force expert. So the experts that you use in a case are very important to make your case.
Is the counter-argument to that say, how can you have an expert who wasn't there at the shooting really explain what the right or wrong thing to do is? The only person that really could do that is Jason Van Dyke or another officer who was there. I mean, is that a good argument to make?
Well, if I may play devil's advocate,
please
how
do.
can you have a jury make a decision when they weren't there either?
Now, that's why you're a great attorney. I like that point, and that's really the most important point. What we can't forget is we're going to take a break, but when we come back, we're going to show Jason Van Dyke taking the stand, and I can't wait for your opinion on this because this is a huge moment. We weren't sure if he was going to. We felt that he must. And boy, did he. So when we come back, you're going to see Jason Van Dyke, the defendant, on the stand. Stay tuned.
I stopped shooting. I put my gun down.
Can you stand up and show the jury what you did, please?
Initially, I was like this. I put my gun down to maybe a 45-degree position. And I started to approach while yelling at him, drop that knife.
All right. He still had dropped the knife, is that right?
No, he did not.
And when he was on the ground, what, if anything, did you observe about him while he was on the ground?
All I could see, I could see him starting to push up with his left hand off the ground. I see his left shoulder start to come up. I still see him holding that knife with his right hand, not letting go of it. And his eyes are still bugged out. His face has got no expression on it.
During that time on the ground, did you say anything to him?
I'm yelling at him, drop that knife.
How many times do you think?
I couldn't tell you.
Okay, that's Jason Van Dyke, the defendant. Sanford, as you're listening to this, does he seem remorseful? Does he seem credible? Is there anything that stood out from you from when he's testifying?
Well, I think he had to testify. Based on the case the prosecution put on, he had no choice. What happens in terms of the jury finding him credible or not credible is the real issue here. And I think we know the result. And I don't think that the jury found him to be credible in terms of the defense that he was presenting, perhaps because the facts of the case, the video, shows what really happened, and there's no way to explain it away.
So really, he said, Laquan McDonald's eyes are bulging, he would advance towards me. None of that, the advancing towards him, that didn't happen. Is it realistically to believe that he just lied on the stand, or is it the idea that his perception is just different, and he was reacted differently? Does he honestly believe that? Could that be a reason?
Well, that's a great argument of a defense lawyer. But the fact of the matter is, once again, back to the pictures of the truth, it shows what really happened. And it's not what he testified to. And a jury very well, and probably did in this case, actually we know he did it, did in this case, they penalized him for it by finding him guilty. Because when you lie to a jury, the instruction from the judge is, if he lied about one thing, then perhaps he's not credible about anything else.
Well, we have a lot more to talk about with Jason Van Dyke. But before we do, let's catch up with Aaron Keller, host of the Daily Debrief here on Law and Crime. Aaron, it's great to see you.
Jesse, good to see you this afternoon. We rarely cross paths, but we are on the same screen together. Look, it is my privilege. Let's talk about the debrief, though. A lot has happened since we last saw you live because of the Christmas holiday, of course. One of the big stories making news nationwide is the charges against actor Kevin Spacey. He is charged with an incident that happened on Nantucket several years ago. We're going to break down those charges, talk about what he is going to be facing with an upcoming arraignment a couple of weeks from now on Nantucket off the coast of Massachusetts. Plus, Supreme Court Justice Ruth Bader Ginsburg back home after a holiday stay in the hospital. Of course, we know she tripped, fell, broke some ribs a couple of weeks ago. That led to additional tests. Those tests ultimately indicated that she had a couple of malignant tumors. Those were removed. We'll let you know how she's doing. Plus, the government shutdown, also in the news, will explain its effects on the courts. And, of course, the holidays were not necessarily merry or bright for everyone out there. We're going to have a quick recap of criminal incidents that happened involving Christmas. That's coming up on the debrief at 5 o'clock Eastern. Jesse, I know I will see you then.
I'm definitely going to be watching. You have great stories, great reporting by our very own Aaron Keller, so we encourage everybody to go watch that later on in the program. Thanks, Aaron. We are going to take a quick break. When we come back, a lot more discussion in the Jason Van Dyke trial.
Again, I'm sorry, I don't remember exactly what I said to the detective immediately after the shooting. I was in shock.
How about what you said to Detective Walsh on the way there? Oh my God, we're going to have to shoot the guy. Why'd you say that?
I didn't talk to a Dr. Walsh.
A Detective Walsh.
Officer Walsh, ma'am.
Officer Walsh?
Yes.
Okay. Why'd you say to him, oh my God, we're going to have to shoot the guy?
I thought the officers were under attack.
Okay, at the
And
point that you thought,
ma'am, I'm still trying to answer. I thought he was under attack, and the whole thing was just it was shocking to me.
shocking, you responded to several calls over your years of people with knives, correct?
I've encountered a few, yes.
And the only thing that you knew at that point was that they had pulled in, popped a tire, and somebody had a knife, correct?
I had heard over the radio that he had slashed the tire, yes.
Over the radio never says slash the tire, does it?
I now know that, yes, I misinterpreted it at the time.
Okay, but what you heard was pop the tire, right?
At the time, I thought I heard slashed.
Okay, that's the defendant on the stand. How do you think he did?
I don't think he did very well. I don't remember. He's not a believable witness, in my perspective, as to what he is trying to present to the jury. So I don't think he did very well.
Well, he got caught up a little bit when he's like, that wasn't my perspective, the dash cam footage that we all see. So what's my perspective? They said, oh, okay, let's show you your perspective. And they showed that digital model, the 3D display. And I mean, can you get more of a clearer perspective? And then he continued to say, well, that doesn't show my exact view. Is there an argument there to say even that model doesn't show his view?
You know, once again, what else is he going to say? I mean, he's trying to present himself as an honest witness, yet his answers do not make him appear to be credible.
And yes, but you had made the point that it was necessary for him
absolutely.
to take. What could he have done differently?
I think perhaps what he could have done differently was not shoot Laquan McDonald.
Yes,
that's a given. And once his defense is stuck with the fact that there is a video of it, I would think that. And he had to testify. There's no question about that. But I would think that he might have been prepared better than he was, based on what I've seen in his testimony.
Well, he seemed to be a little combative with the prosecutor, and maybe that wasn't for the best thing. I'll tell you what, though, we're going to take a break. When we come back, we're going to start with the end with the conclusion of the Jason Van Dyke case, and we're also going to talk a little bit more about the police cover-up trial. So we'll be right back here on Law and Crime.
So I was given additional information. I read Dr. Miller's report. I had a telephone interview with Officer Van Dyke, and based upon those two additional sources of information, I rendered an opinion that the second volley, that Officer Van Dyke was still under imminent threat by his observations, and I felt that that was a reasonable conclusion.
And when you say by his observations, did you determine that his observations were reasonable for a police officer in that same situation?
In dealing with a lot of these prior cases that are captured either on an officer's body camera, which isn't the situation here, or with the car cam, they very rarely show what the officer is actually seeing or what the actual lighting conditions are that the officer's eye is seeing. You know, the cameras will pick up different lighting variations, and the shutter on a body cam will show light situations that are more favorable. So what answered my questions was having Officer Van Dyke tell me what he was looking at when he decided to fire that second volley.
So the defense's expert said the shooting was justified, including both volleys of shots, both rounds of shots. Sanford, what is the jury supposed to do here? They have one use of force expert saying it's not justified and another one saying it's justified.
Well, the question is, which witness does the jury find more credible? Or perhaps they cancel them both out. But once again, I keep on going back to that video. You got a video of what happened here, and the jury's going to make up its own mind, irrespective of what the experts might say.
And they have a lot to consider here. Yes, the video. Yes, the experts, the testimony of fellow officers who were there, the testimony of eyewitnesses. And now, without further ado, let's see what the jury ultimately came back with. Here is the verdict in the Jason Van Dyke trial.
With this understanding, will you please read the verdicts?
We, the jury, find the defendant, Jason Van Dyke, guilty of second-degree murder. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, first shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with a firearm, second shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, third shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, fourth shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, fifth shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, sixth shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, seventh shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, eighth shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, ninth shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, tenth shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, 11th shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, 12th shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, 13th shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, 14th shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, 15th shot. We, the jury, find the defendant, Jason Van Dyke, guilty of aggravated battery with firearm, 16th shot. We, the jury, find the defendant, Jason Van Dyke, not guilty of official misconduct.
At this time, Mr. Herbert.
Judge, please not hold the jury.
Can I have the attorneys over here for a second?
Let's break down the verdict and what's to come right now. So Sanford, first up, he was found guilty of second-degree murder and 16 counts of aggravated battery for every one of those shots. Is that a surprising verdict?
I wasn't surprised. But I think what we have to look at is there's no winners or losers here. A young man is dead.
Right.
A police officer, his life is ruined. But we hope that from this verdict, perhaps, what happened here won't happen again.
I agree with you. That's the hope. But the question is, what really happened? The jury said not guilty on official misconduct, but he's guilty of murder and aggravated battery. How did they reconcile that?
Well, official misconduct is such a small piece of this. I think the jury was convinced that what he did was criminal, that it was second-degree murder, and the 16 counts in addition were crimes that he was guilty of. So I think the jury evaluated that, and the official misconduct, maybe they felt on a technicality of some sort, that wasn't appropriate. But the bottom line is, on the serious charges here, they found him guilty.
Now, we believe he's going to appeal.
Of course.
His sentence hasn't been laid out yet. We believe it's going to be happening on January 15th. What could his sentence be? Now, that's a video of him, what he looks like now. Clearly, he looks a lot different than when his trial happened. Looking very different. What do you think his sentence could ultimately be?
Well, I think it depends if the judge is going to sentence him concurrently or consecutively. Concurrent sentences means that even though you're found guilty of more than one crime, your sentence will be served together for each crime. So if you're found guilty of 17 crimes, you're only going to serve one sentence. But if it's consecutive, each penalty for each crime adds up. So that's going to be a very important aspect of the sentencing in this case.
Is it the more atrocious the crime, the more the better that it would be consecutive and not concurrent? That's
well,
the way it would work?
I think the judges look at a lot of factors, and one of those is the seriousness of the crimes. Because remember, consecutive sentencing means that you're going to serve the sentence for second-degree murder and then the sentence for 16 counts of another crime, each one individually added on.
Do you think he's going to face prison time, significant prison time, no prison time?
I would suggest significant prison time.
You do?
Because second-degree murder is a very serious crime. And the 16 counts added to that, I think jail time is appropriate, and I think it will be a sentence of jail time.
Well, this is chapter 1 in the Laquan McDonald saga. We actually covered Van Dyke about a week ago. His attorneys tried to make an appeal, tried to make a plea for the judge there to throw out the verdict and grant a new trial. That was denied, and so he is going to be facing his fate in January. But here, we're going to focus on chapter 2, the police cover-up part of the Laquan McDonald shooting. We'll be back. Okay, let's break this down right now with civil litigator Sanford Rubenstein. Sanford, we're watching this, and maybe I'm naive, maybe our viewers can't believe it. Is it realistic to believe that officers, detectives, falsified police reports? Is that an actual possibility?
I would suggest to you, not only is it realistic, but it may very well have happened in this case. I think this trial is as important as the Van Dyke trial, because one of the biggest problems you have with the public having credibility in the police is situations in which police attempt through conspiracy among themselves to cover something up. And if in fact these three defendants did that, and I think the evidence the prosecution presented makes a good case for that, then it's as important as it is in the underlying case, the Van Dyke case, to bring this case to trial. A jury is waived by the defense in this case. The judge in this case, it's a judge-only trial, will make the determination. But it's a real problem in our society, the problem of cover-ups by police to try to protect their brother police officers. Some call it the blue wall of silence.
But the idea here, the strong evidence that you said, they make a strong case, is what? That the reports have similar language, that it classified Laquan McDonald as an offender, as them as the victims? I mean, what did you see from the reports themselves that seemed to be suspicious?
Well, I think more so than the reports, it was the testimony of one of the officers who turned on those who were being tried, who said, I didn't say that. And it was put in the report as if I said it to attempt to cover this up. Very, very important evidence, which I believe will lead to a conviction in this case.
You're talking, of course, about Dora Fontaine, whose testimony we're going to talk about a little bit later on. We'll take a quick break right now, but when we come back, we have a lot more to talk about, including there was an outburst on the stand from one of the witnesses, and you're not going to want to miss it. So stay tuned here on Law and Crime. All right, that was Officer Joseph McGilligot, a key witness both in this trial and Van Dyke. Sanford, I would be curious to ask you, do you think that if he had fired one shot that night, that officer, we might have seen a whole different kind of trial? Because he felt there was a threat, but he didn't feel it was justified enough to open fire. But if he had fired one shot, whether it hit McDonald or not, that might have been a different kind of case?
No, I agree. I think the result might have been different, because I think his testimony that he did not believe it was necessary for him to fire any shots was very significant in the jury making the determination of guilt.
Right. I mean, because Van Dyke was the only one that opened fire, and opened fire so many times. The other side of this, though, and when you watch Officer McGilligot, how tough is it for him to testify against his fellow officers?
I think it's one of the toughest things that a police officer has to do, particularly because if he goes back on the force and he's out in the field, he has to worry about if his back is being watched.
You mentioned that before, and we're going to play the testimony of Dora Fontaine, the idea that she was labeled a rat for changing her story, and we'll get into that in a second. Does that exist in police departments, that, hey, your priority is the police department, your brother officers, no matter what the truth is?
You know, I would suggest that it does exist, but I would also suggest that there are police officers like Dora who are heroes. They're the real heroes, because they're coming forward in spite of whatever the personal consequences may be to them and telling the truth.
And speaking of Dora, we are going to get to her testimony right after this break, so stay tuned here as we continue our coverage of the Laquan McDonald shooting. Welcome back to Law and Crime, everybody. You know, we can't talk about the police cover-up trial in relation to the Laquan McDonald shooting without talking about Officer Dora Fontaine. Now, she claims that a false statement was attributed to her in her police report, in David March's police report, that she said that Laquan McDonald was as if he was attacking Jason Van Dyke that night. She has vehemently denied that, said she never made that statement, and that it is just false. And she claims that Officer David March made this up. The fact that she changed her story, according to the prosecution, according to the defense, that she was labeled as a rat, that she wanted to change her story to protect her job. In other words, that she really did believe Laquan McDonald was the attacker, but when everything came out about what was really happening in the shooting, she changed her story in order to save her job. We're going to play you her testimony right now, and this was a key moment, both for the prosecution and the defense. Take a look.
Car, you hear drop the knife, you see the individual I believe you said fall, you saw smoke?
Twist the phone.
Okay. Did you draw your gun?
No.
All right. Was the individual shot while he was lying on the ground?
Yes.
Did you see anyone approach this individual while he was on the ground?
Yes.
Who?
Officer Walsh.
Officer Walsh, do you know him personally? Are you familiar with Officer Walsh?
Yes.
You see him in the courtroom today?
Yes.
Can you point him out, please, and identify him?
We'll stipulate that Officer identified Officer Walsh.
Okay, there's an in-court identification of Defendant Walsh.
As you were observing this individual, Laquan McDonald, get shot, did you observe him raise his arms trying to threaten anyone?
No.
Did you observe him raise his arms in an attempt to stab anyone?
No.
Did you observe him make any aggressive moves as if he was going to attack anyone?
No.
Did you observe him lunge at anyone?
No.
Did you observe him charge at anyone?
No.
After he fell to the ground, did you observe him move?
Judge, I'm objecting to beating on direct.
I agree. He's throwing that objection.
That is sustained.
What did you observe, if anything, while he was on the ground?
Twitching.
Did you observe anything else with respect to his movement while he was on the ground, or his twitching while he was on the ground?
Just twitching.
Okay, so Sanford, she's an interesting witness because the defense painted her as somebody who would do anything to save her job, that she was a lazy police officer because she changed her story after initially coming forward and saying that, well, Laquan McDonald seemed to be the attacker. She's claiming that was a false statement. She never made that statement. She knows what she saw. So what's a jury supposed to do here?
I think you look at her credibility. In my evaluation of her, I think she's a credible witness. And what would the reason be, really, if she's going to make all these statements and then say she never made them? What's her motivation? I don't see it.
To protect her job.
I don't see it.
Because she knew that other people were coming under fire for this shooting. You know, look at the three officers, look at Van Dyke. Maybe she said, well, wait a second. If I came forward and said this, it's going to make me look like I was trying to cover up what happened. Look what happens to these three officers.
I would suggest to you that the opposite happened. That she realized that these statements that were put in official reports were simply not true and felt she had to come forward and tell the truth. I think the jury is going to evaluate her as a truthful witness. Actually, it's not the jury, it's the judge, because there's no jury in this case. The judge is going to evaluate her as a truthful witness, and I think her testimony is very significant. As a matter of fact, probably one of the most significant pieces of testimony in this trial.
She's an officer claiming that the reports were falsified. This is different than anything else.
Which gives her even more credibility, because why would she put herself at risk, her career at risk, by making this up that she never said any of those statements unless it was true?
And her life must not be easy being in the police department right now, considering, again, what is being at stake here. These are the officers' lives, and she is being claimed to be testifying against them. Maybe the same thing as Officer Joseph McGilligot.
I would suggest she had a moral compass, and she followed that moral compass and is telling the truth in this trial as to the fact that statements were attributed to her which simply were not true. And she's so offended by that she's coming forward in spite of the personal risk to her and telling the truth to this judge.
Let's continue on. Let's play a little bit more of Officer Dora Fontaine.
Next, we would like to show you People's Exhibit March GPR 1. You see that exhibit?
Yes.
What is it?
A general progress report.
And on the top right, what is the date of this report?
20 October 2014.
And on the bottom left corner, who is listed as the reporting officer?
David Marsh.
And is there a star number?
Yes.
What's that number?
20563.
Have you ever seen this report, or had you been given an opportunity by David Marsh to see this report?
No.
Did you ever observe Laquan McDonald raise his arm as if attacking Van Dyke?
No.
Did you make that statement to Defendant Marsh?
No.
Is that statement false based on what you witnessed of the shooting?
Objection, Your Honor.
That calls for a conclusion, so
Yes.
that is sustained. Didn't interrupt your objection.
Did Defendant March ever give you an opportunity to review or revise this report before it was submitted?
No.
That's the answer.
That's a rule.
Okay, Officer Dora Fontaine there on the stand. One of the things you can't forget as I was listening to this, we hear the judge ruling on objections, but she's the fact finder too. How tough is it, do you think, for the judge to sit there and be both the jury and the judge?
Well, I think it may be tough, but I think a judge is smart enough generally to be able to do exactly that. I think the rulings on evidence are basically evidentiary rulings. Some things should be let in, some things shouldn't. And she knows to only consider, as she makes her verdict, those things which should come in. So I think in this case, you're probably better off with a judge than a jury who may very well be influenced by things that come out which may not be actually proper evidence.
Human being, easier said than done. I mean, a lot of times when there's objections or things happening, the jury is removed. That decision is made outside their presence. They don't hear it. Judge is hearing everything. Impartial decision maker, easier said than done. We're going to take a break. When we come back, a lot more to discuss in the police cover-up trial. Welcome back, everybody. We're talking about the Laquan McDonald shooting, and when we first started off, we played you the highlights from the Jason Van Dyke trial, and clearly there's going to be overlap between that trial and the trial we're focusing on right now of the 3 officers who were on trial for allegedly covering up what really happened that night in order to protect their brother officer, Mr. Van Dyke. And one of those overlaps is the testimony of Officer Joseph McGilligot. This was Defendant Thomas Gaffney's partner. McGilligot did not fire his weapon that night. Nope, he was such a critical witness for the state in the Van Dyke case. Now he has to testify once again in a different trial involving other officers. Let's see how he did.
What happened as you approached Carl?
Officer Gaffney used the car to try to block his path.
And what happened when Officer Gaffney did that?
He turned the car in front of him, and Laquan McDonald continued walking, and he walked into the car, and he turned, like spun, and he had his back to the car, and he slammed the knife down and stabbed the front passenger right wheel.
So he has back to the car and
stabbed the tire.
And which tire did he stab with his back to the car?
The front passenger.
Was anyone in the passenger seat of the car?
No, I was outside the car.
And how far away from you were you at this point?
10 or 15 feet.
What happened after Mr. McDonald stabbed the tire?
He continued walking. He walked away from the car and continued walking.
And what happened then?
After all the air went out of the tire, my partner attempted to block him off again.
And what happened then?
He walked into the squad car and stabbed the windshield.
Did you feel at that point that Mr. McDonald was about to batter Officer Gaffney?
I felt that he was protected. My partner was protected by the car, and the window did not shatter. So in my eyes, he was still a potential threat to hurt us, but he was protected for the most part.
Did you feel that Mr. McDonald had used force likely to cause death or great bodily harm?
If he had broken the window, it would have been different, but I felt he used force, but it was our car, so
the answer to the question.
We continued to monitor his actions.
The question is, did you feel, given that the windshield did not shatter, and that Officer Gaffney was in the car, did you feel that Mr. McDonald had used force likely to cause death or great bodily harm?
Not toward me, he did not.
Towards anybody?
Yes.
What did you do then?
When they went out onto Pulaski, I stopped at the sidewalk because oncoming traffic was coming from the ramp on my left.
And what did you do after?
I walked up to the traffic light, and I stopped in the street. I waved the squad car in front of me, and they had cars to my right. I turned around and I stopped traffic from coming further southbound.
And what happened?
I heard gunshots.
Was your back turned towards the gunshot?
Yes.
Officer McGilligan, I understanding your testimony that you believed Mr. McDonald was a threat because he had a knife, correct?
Correct.
Did he ever make any threatening moves towards you?
No.
Not even when he was within 10 feet of you, facing you with a knife in his hand?
No.
Did he ever, or let me strike that. Why didn't you shoot Mr. McDonald?
I didn't feel that it was necessary at that point.
Even though he had damaged your vehicle?
He hadn't make he had not made any moves toward me to put my life in jeopardy.
If he had put your partner's life in jeopardy, would you have shot?
Yes.
What happened? Now, you were at the scene for some time, is that correct?
Yes.
What happened when you got back to the station?
We went to the area to meet with the detectives.
And where was the area?
51st and Wentworth.
And when you got there, or after you got there, was anyone viewing the video?
Yes.
Who was viewing the video?
I only saw the viewing of that people were watching the Dunkin' Donuts video.
And who was doing that?
Several detectives, Officer Van Dyke, Officer Walsh.
And was anybody saying anything during the viewing of the video?
They were just discussing the positioning of where they were and during when he was shot.
Did anybody say anything about backpedaling?
I remember hearing somebody saying that Joe Walsh had been backpedaling.
Do you know who said that?
No.
Were they saying anything about what Officer Van Dyke was doing?
They were just trying to see the positioning of where he was. I guess measuring, trying to see how many feet away he was and things like that.
Did you recall anybody saying anything about backpedaling with that?
I don't recall that.
Did you complete a TRR?
No.
All right, that was Officer Joseph McGilligot, a key witness both in this trial and Van Dyke. Sanford, I would be curious to ask you, do you think that if he had fired one shot that night, that officer, we might have seen a whole different kind of trial? Because he felt there was a threat, but he didn't feel it was justified enough to open fire. But if he had fired one shot, whether it hit McDonald or not, that might have been a different kind of case?
No, I agree. I think the result might have been different because I think his testimony that he did not believe it was necessary for him to fire any shots was very significant in the jury making the determination of guilt.
Right. I mean, because Van Dyke was the only one that opened fire and opened fire so many times. The other side of this, though, and when you watch Officer McGilligot, how tough is it for him to testify against his fellow officers?
I think it's one of the toughest things that a police officer has to do, particularly because if he goes back on the force and he's out in the field, he has to worry about if his back is being watched.
You had mentioned that before, and we're going to play the testimony of Dora Fontaine, the idea that she was labeled a rat for changing her story, and we'll get into that in a second. Does that exist in police departments that, hey, your priority is the police department, your brother officers, no matter what the truth is?
I would suggest that it does exist. But I would also suggest that there are police officers like Dora who are heroes. They're the real heroes because they're coming forward in spite of whatever the personal consequences may be to them and telling the truth.
And speaking of Dora, we are going to get to her testimony right after this break, so stay tuned here as we continue our coverage of the Laquan McDonald shooting. Welcome back to Law and Crime, everybody. You know, we can't talk about the police cover-up trial in relation to the Laquan McDonald shooting without talking about Officer Dora Fontaine. Now, she claims that a false statement was attributed to her in her police report, in David March's police report, that she said that Laquan McDonald was as if he was attacking Jason Van Dyke that night. She has vehemently denied that, said she never made that statement, and that it is just false. And she claims that Officer David March made this up. The fact that she changed her story, according to the prosecution, according to the defense, that she was labeled as a rat, that she wanted to change her story to protect her job. In other words, that she really did believe Laquan McDonald was the attacker, but when everything came out about what was really happening in the shooting, she changed her story in order to save her job. We're going to play you her testimony right now, and this was a key moment, both for the prosecution and the defense. Take a look.
Car, you hear drop the knife, you see the individual, I believe you said fall, you saw smoke.
Twist the phone.
Okay. Did you draw your gun?
No.
All right. Was the individual shot while he was lying on the ground?
Yes.
Did you see anyone approach this individual while he was on the ground?
Yes.
Who?
Officer Walsh.
Officer Walsh. Do you know him personally? Are you familiar with Officer Walsh?
Yes.
You see him in the courtroom today?
Yes.
Can you point him out, please, and identify him?
We'll stipulate that Officer Pine identified Officer Walsh.
Okay, there's an in-court identification of Defendant Walsh.
As you were observing this individual, Laquan McDonald, get shot, did you observe him raise his arms trying to threaten anyone?
No.
Did you observe him raise his arms in an attempt to stab anyone?
No.
Did you observe him make any aggressive moves as if he was going to attack anyone?
No.
Did you observe him lunge at anyone?
No.
Did you observe him charge at anyone?
No.
After he fell to the ground, did you observe him move?
Judge, I'm objecting to beating on tracks.
I agree. I was going to object.
That is sustained.
What did you observe, if anything, while he was on the ground?
Twitching.
Did you observe anything else with respect to his movement while he was on the ground, or his twitching while he was on the ground?
Just twitching.
Okay, so Sanford, she's an interesting witness because the defense painted her as somebody who would do anything to save her job, that she was a lazy police officer because she changed her story after initially coming forward and saying that, well, Laquan McDonald seemed to be the attacker. She's claiming that was a false statement. She never made that statement. She knows what she saw. So what's a jury supposed to do here?
I think you look at her credibility. In my evaluation of her, I think she's a credible witness. And what would the reason be, really, if she's going to make all these statements and then say she never made them? What's her motivation? I don't see it.
To protect her job.
I don't see it.
Because she knew that other people were coming under fire for this shooting. You know, look at the three officers, look at Van Dyke. Maybe she said, well, wait a second. If I came forward and said this, you know, it's going to make me look like I was trying to cover up what happened. Look what happens to these three officers.
I would suggest to you that the opposite happened. That she realized that these statements that were put in official reports were simply not true and felt she had to come forward and tell the truth. I think the jury is going to evaluate her as a truthful witness. Actually, it's not the jury, it's the judge, because there's no jury in this case. The judge is going to evaluate her as a truthful witness, and I think her testimony is very significant. As a matter of fact, probably one of the most significant pieces of testimony in this trial.
She's an officer claiming that the reports were falsified. This is different than anything else.
Which gives her even more credibility, because why would she put herself at risk, her career at risk, by making this up that she never said any of those statements unless it was true?
And her life must not be easy being in the police department right now, considering, again, what is being at stake here. These are the officers' lives, and she is being claimed to be testifying against them. Maybe the same thing as Officer Joseph McGilligan got.
I would suggest she had a moral compass, and she followed that moral compass and is telling the truth in this trial as to the fact that statements were attributed to her which simply were not true. And she's so offended by that that she's coming forward in spite of the personal risk to her and telling the truth to this judge.
Let's continue on. Let's play a little bit more of Officer Dora Fontaine.
Next, we would like to show you People's Exhibit March GPR 1. You see that exhibit?
Yes.
What is it?
A general progress report.
And on the top right, what is the date of this report?
20 October 2014.
And on the bottom left corner, who is listed as the reporting officer?
David Marsh.
And is there a star number?
Yes.
What's that number?
20563.
Have you ever seen this report, or had you been given an opportunity by David March to see this report?
No.
All right. The first line, it says D. Fontaine. Would that be you?
Yes.
And this report indicates, and I'll quote, O ignored, raised R arm toward BD as if attacking BD. Did I read that right?
All right, if I can interpose an objection here. For
Yes.
the record, this was an exhibit that myself and Mr. Fahey, we objected to earlier. Just want to make sure the court understands that that objection is running for these exhibits.
Thank you for that. And the record is clear on that now. So the objection is noted. Continuing the objection on this document, correct, Mr. Pugh?
Yes, sir.
All right, and Mr. Fahey?
Yes.
All right, that objection is noted but overruled. Okay.
What does O mean?
Offender.
What does R mean?
Ignore. Oh, right.
What does BD mean?
Van Dyke.
So the translation would be offender ignored, raised right arm toward Van Dyke as if attacking Van Dyke. Would that be how that would be read?
Yes.
Did you ever observe Laquan McDonald raise his arm towards Officer Van Dyke?
No.
Did you ever observe Laquan McDonald raise his arm as if attacking Van Dyke?
No.
Did you make that statement to Defendant March?
No.
Is that statement false based on what you witnessed of the shooting?
Objection, Your Honor.
That calls for a conclusion, so
Yes.
that is sustained. Didn't interrupt your objection.
Did Defendant March ever give you an opportunity to review or revise this report before it was submitted?
No.
That's the answer.
That's a rule.
Okay, Officer Dora Fontaine there on the stand. One of the things you can't forget as I was listening to this, we hear the judge ruling on objections, but she's the fact finder too. How tough is it, do you think, for the judge to sit there and be both the jury and the judge?
Well, I think it may be tough, but I think a judge is smart enough generally to be able to do exactly that. I think the rulings on evidence are basically evidentiary rulings. Some things should be let in, some things shouldn't. And she knows to only consider, as she makes her verdict, those things which should come in. So I think in this case, you're probably better off with a judge than a jury who may very well be influenced by things that come out which may not be actually proper evidence.
Human being, easier said than done. I mean, a lot of times when there's objections or things happening, the jury is removed. That decision is made outside their presence. They don't hear it. Judge is hearing everything. Impartial decision maker, easier said than done. We're going to take a break. When we come back, a lot more to discuss in the police cover-up trial. Welcome back, everybody. So we're covering the police cover-up trial, and we can't talk about this in a box. In other words, we have to look at the communications throughout the entire police department. And one of the things that we saw was a collection of emails between other Chicago officers, those who are not in the courtroom, was presented to the judge. And I want to play some of that testimony. And Steve Maris is from the Information Services Department at the Chicago Police Department, and he is going to talk more about these emails. Let's see what we can learn.
Can't overkill a person who is still alive at the hospital.
Yes.
Turning to the next paragraph down, does Daniel Gallagher write to Anthony Wojcik, "We are trained to shoot until the threat is eliminated, defeated, or neutralized." Officer did exactly what he was trained to do.
Yes.
Does Daniel Gallagher then write to Anthony Wojcik, "Offender kept knife in hand entire time. Offender never chose to abide by officer's commands. Offender chose his fate, possibly suicide by police."
Yes.
Interesting communication there between two people who are not in the courtroom, Lieutenant Anthony Wojcik and Sergeant Daniel Gallagher. And Sanford, what it seems to suggest is they believed, or at least in this communication, that the shooting was justified. How do you think that plays into this whole overall police cover-up case?
Well, I think it shows that it wasn't just the defendants on trial who were attempting to cover up what happened, trying to give explanations for what happened to try to help their fellow police officer not be found guilty is what this appears to be.
I wonder how much is a cover-up and how much is just an analysis of figuring out what happened.
We don't know for sure. But if you look at all of the facts in this case, particularly Dora's testimony, which is so significant, it's clear to me that the evidence that's been presented to this judge is enough for her to find a cover-up.
Now, one of the witnesses, one of the defendants that's singled out more than anybody is Detective David March. And one of the final witnesses we saw in this trial was Detective Nancy Pekarsky, who is a retired police officer. And she talks about how March had responsibility over the reports. That's a key fact. Let's see what she had to say.
Can you tell us what this is?
This is my supplementary report.
Did you have a chance to review it before testifying for today?
I did.
Does it appear to be the same, substantially the same position today as it was when you prepared it on October 21st, 2014?
Yes.
When you prepared this report on October 21st, 2014, did it share the same RD number as Officer Fontaine's report that we just looked at?
Yes.
And at what time did you submit your report? In other words, press enter on your computer.
15:02 hours. I submitted. I'm sorry.
But if I misspoke, I apologize. What time did you submit the report?
15:01 hours.
3:01 in the afternoon?
Yes.
We should go to Fontaine's report again, please. Page 4. Taking a look at the state's exhibit, do you see the time do you see the date and time near David March's name that you put in there?
I did.
And what is that?
21 October 2014, 15:01 hours.
Knowing that it has the identical date and time as your report, does that mean you're the person that put March's name on Officer Fontaine's report?
Yes.
All right. Prior to that, did David March, to your knowledge, have access to Officer Fontaine's report? And on Officer Fontaine's report, does it say, after you inputted David March's name and contact information, does it say that Officer, strike that, does it say that Detective March reviewed Officer Fontaine's report?
No.
Does it say that Detective March approved Officer Fontaine's report?
No.
So I believe what the line of questioning there was who was responsible for the reports. Did she put David March's name on Officer Fontaine's report? Sanford, the thing that I'm curious more about is the defense, particularly David March's attorney, really made the argument that if he wanted to cover something up, he was responsible for a lot of the evidence. He could have thrown that videotape in I think he said Lake Michigan or something like that. He could have taken that tape and thrown it away. He could have done more to hide evidence if he really wanted to cover something up. What do you think about that argument?
Well, when one has very little to argue, as in this case, I believe, with regard to the fact that there is testimony from Dora that the report was a lie in terms of what she said, you look at worst case scenario. Yes, it's possible he might have done more, but then again, might have there been more of a risk for him to be guilty of conspiracy had he done that. So I don't see it as an explanation that flies.
Now, we're about to play. The defense made a motion for a directed verdict, basically to end the trial before, they even had to put on a case, take it out of the judge's hand in a way. How often are those motions granted, especially here with the judge deciding everything?
Well, it's interesting because they're asking for the judge to make a determination in a directed verdict before she makes a determination after all the evidence is in. So I think the fact that the judge did not grant that motion is an indication of where she may very well be going in this case.
You believe that?
I think so.
Okay, well, let's see. They made a very strong motion for a directed verdict. This is first the attorney for David March. Let's see what he had to say.
There is no evidence of an agreement. It doesn't have to be direct. It could be implied, but there is no evidence that an agreement was implied. The prosecution kept saying throughout this case, parallel false reports. These are false reports. They keep spitting out the word false reports as if it's true. It's not. The more they say it, the more they want you to believe it because they don't have any evidence to prove it. Look, we can all look at a video and interpret different things. Dave is merely an investigator writing out what witnesses tell him. You know from the evidence, Judge, from the witness that testified, you know that the Cook County State's Attorney's Office and the FBI were conducting interviews in January 2015. You know that not only was the Cook County State's Attorney's Office involved in an investigation, so was the U.S. Attorney's Office. You know from witnesses who testified and were impeached by federal grand jury testimony, the federal government was involved in this investigation in 2015. You know that in addition to the FBI, the U.S. Attorney's Office, the Cook County State's Attorney's Office, the Office of the Inspector General was taking sworn statements from people in this case. To charge David March and others that they are hiding facts from independent criminal investigators, that's a laugh. That's a joke. A bad one, but that's a joke.
That motion for directed verdict was ultimately denied. Now, Sanford, I want to go back to what you said. You said the judge denying that might be a glimpse into what her ultimate decision would be. But aren't that two different standards, whether or not that she finds them guilty and whether or not she granted that motion?
I would think the facts that she's going to base her determination on are the same. This appeared to me to be a summation as opposed to an argument on a motion. I think he'd say the same thing when he sums up. So I think we have a glimpse now into the mind of the judge, and I would be very surprised if she acquits them.
Would you see a situation where we heard so much about David March, but maybe not so much about the other defendants, where she might split the verdicts?
Anything's possible. Anything's possible. But I think that the verdict, in all likelihood, would be guilt or not guilty for all three.
Interesting. So, but isn't conspiracy tough to prove?
Yes, it's very tough to prove because you have to prove they acted in concert. Whether they did prove that during this trial, the prosecutors, to the satisfaction of this judge, we'll know very soon.
So let me ask you this. You said it might be a split. Maybe you said no. It would either be all or nothing.
That's what I think.
Do you think it'd be all or nothing?
But it's possible it could be a split.
Right, it could be a split. But do you think it could also be all or nothing in terms of the charges? In other words, maybe they'd be found guilty of obstruction of justice, but not and official misconduct, but maybe not conspiracy?
Once again, that's a possibility also. It's possible that that could happen. But I think, once again, that it's going to be all or nothing.
And what happens if they're found guilty? What is that reaction across the nation into police departments? Because you said this happens a lot with officers falsifying reports.
Well, I think that if anything, it sends a message to officers throughout the country that if you do falsify reports, you will be held accountable, and you could very well go to jail as well, and will have an effect on the future in terms of this ever happening again.
Well, Sanford, maybe the whole world will be watching this as they did the Jason Van Dyke verdict. We'll have to see. Now, you stick around because you're going to be up next on Aaron Keller's Daily Debrief. You're not going to want to miss that. Talking about a lot of interesting cases tonight, including the Kevin Spacey scandal. I am going to be signing off. We'll be back here on the Law and Crime Network tomorrow at 9 a.m. Eastern Standard Time. In the meantime, we'll be right back with the Daily Debrief.